Hey everyone, real quick, I'm gonna do a 5-minute video, and what I wanna talk about is a very common type of lawsuit that can pose a tremendous risk to a company. Now, I want to expand the definition of company because where I've been seeing it more and more is nonprofits, right? And if it's a real nonprofit, they'll have an actual building somewhere and they'll have employees and they'll have a staff and they might have an executive director, they might have a finance team and a marketing team, whatever. So it's being run like a real organization and they don't know that they also need to follow all of the labor and employment laws. And so here's kind of your fact pattern. The executive director maybe comes from the charity world. If it's art related, maybe they come from the art world or whatever it is. And they get put in this position where now they're leading a team, they have an organization, and they've got to make payroll, and maybe there's a budget and a board of directors and all this stuff. And they need to make sure that they're competent and educated on the Fair Labor Standards Act. All right, so let me do a crash course on the Fair Labor Standards Act. So first things first, we're only talking about workers in the United States. So if your company has some offshore people in the Philippines or in India or in Colombia, you probably have to make sure that you're following the laws of that country, but the laws of the United States don't apply to those workers, right? The Congress didn't pass the Fair Labor Standards Act to protect Colombian workers, just not part of their objective. All right, so we're just talking about people in the United States. So then if you divide them in half, you're gonna have people that are independent contractors. Also, you've heard of freelancers. The tax form that they would receive at the end of the year is a 1099. So you hear people all the time talk about a 1099 worker. I hate it when I hear people say a 1099 employee because that is a paradox. All right, so you got independent contractors and you've got employees. An employee receives a W-2. That's the tax form. So you'll hear people say, I have 1099s and I have W-2s. So the labor laws mostly apply only to the W-2s. Now, here's a quick thing. That distinction between a W-2 and an independent contractor, sure, the person can present themselves as an independent contractor, and you could agree to treat them as an independent contractor. But if by law you are taking control, you are setting their schedule, you're telling them when and where and how they have to do their job, then by law, they might be treated as an employee, and we call that a misclassification. And the Department of Labor gets involved. That person could sue you because you maybe didn't pay them overtime because you didn't think you had to, but then the law says, wait a minute, you had control of them. So even though you treated them independent, by law, they should have been treated as a W-2 worker, employee, and so then they should have had all these other protections. Also, the IRS gets involved. The IRS estimates that it loses hundreds of billions of dollars a year in tax revenue by misclassification, right? And a lot of nefarious, evil business owners do it on purpose to save money and try to avoid the taxes. And some of them are just innocently making this mistake, okay? And that's who I'm really talking to. I'm not talking to the people that are nefariously trying to pull one over on the IRS and on the worker. I'm talking about the guy who maybe just doesn't know. And what I keep seeing is in the nonprofit world, they just don't know that the law also applies to them. And I'm telling you, it does. All right, so now we've got our W-2 workers and basically divide them in half, and you've got your hourly people and people that are allowed to be paid salary. Now, technically, you can pay an hourly person salary, but you still have to follow timekeeping and overtime, right? And so the distinction is what we call an exempt and a non-exempt. So an exempt would be an executive, it would be a manager, and it would be a professional. A non-exempt is everybody else. So I've seen them say, hey, person who sits at the front desk and answers the phone Monday through Friday from 9 to 5, and that's your only job description, and you don't manage anybody, we'll just give you a salary. Well, what I'm saying is you can agree to pay that person a fixed amount, but if that person works 1 hour of overtime, you owe them that hour of overtime. And here's where things get tricky. When you have a falling out with that person, and then they go talk to a labor and employment lawyer, the labor and employment lawyer can literally sue you for basically anything. They could claim with no proof that that person worked 200 hours a week. Now, you're like, hey, come on, every once in a while she might have worked an half an hour or an extra hour or whatever, but never 100 hours. Like that's ludicrous. She was lazy or she barely came in and did her job at all. And so what the problem is that once they file that lawsuit, the burden is 100% on the employer to disprove the allegations. So if they say 100 hours and you can't disprove it, you lose. And so that's when you're like, well, why? Well, I didn't have record keeping. I didn't have a time card because we put her on salary. Well, now you just dug your own hole and you walked into your own trap. And so this problem, I see it consistently, where the managers of these organizations don't know the law. They don't know the difference between 1099 and W-2. They don't know the difference between exempt and non-exempt. They don't know the job descriptions of who can be exempt and paid a salary, and I don't need to worry about their overtime, and who I must keep time records. And so guys, this is obviously a big, deep subject. I'm gonna do more videos about this soon. Please give me a call, leave a message, and or just reach out to me, and I'm happy to answer any questions you have.